Welcome back to the Texas Appellate Law Podcast. I'm Todd Smith.
And I'm Jody Sanders.
Our first guest back after a little hiatus is Kevin Dubose. Kevin is a previous guest of the podcast. He did a couple of episodes with us fairly early on in the life of the show on a couple of really important topics. And we'll refer back to those in the show notes for listeners who are interested in hearing about what we talked about with Kevin before. My recollection is primarily that was sort of the institution of the Appellate Bar in Texas. And then secondly, the crafting and adoption of the standards for appellate conduct. Lots of good stuff to listen to in those episodes. And so we'll link those in the show notes. But without further ado, I'll just quickly say that Kevin is a partner at Alexander Jefferson and Dubose, an outstanding appellate boutique firm here in Texas with a lot of great folks. And I don't know if I dare call you, Kevin, one of the deans of the Texas Appellate Bar, but I think you've probably earned the title. So I hope you take that in the spirit with which it was offered.
I feel like more of a professor emeritus than a dean.
Okay. Professor emeritus sounds pretty good to me. We invited Kevin back because he gave a talk recently at the UT Appellate Seminar over the summer back in June. And the title of his talk was Overcoming the Existential Crisis of Being an Appellate Lawyer. And Jody and I got together and talked about this topic and thought, we really identify with this. We're not quite as advanced in our careers as Kevin is, but I'm a little more advanced in mine than Jody is. But I can tell you that all three of us share this concern and desire to, for one, stay on the right track in our careers as appellate lawyers. But two, I think it's beneficial for us to talk about the topic that Kevin's brought up in this paper. And it's really interesting. And I think will do a lot of good for folks who do what we do to hear what Kevin has to say on this topic. So
Definitely.
Kevin, welcome back to the podcast. We're so grateful to have you back.
Thanks. Glad to be here.
Well, let's just jump right into it. We'll refer the folks back to, as far as your background and history and so forth. We'll refer everyone back to the previous episodes. I've mentioned where you're practicing and that hasn't changed. But tell us first of all, I guess how you came up with this topic of there being an existential crisis among the appellate bar and what to do about it.
Which you're not wrong about, by the way.
Oh, no, I 100% agree with that. But I'm interested to hear sort of the impetus of you giving this talk and what's going to help guide our discussion today.
Well, it does have an interesting origin story. And I hadn't shared it with you, and it's not in my paper, so you didn't know to ask this question. But if you hadn't, I was going to introduce it anyway. This topic and this paper, this talk, came to me in a dream. And I mean that literally. I don't mean in the figurative sense of Martin Luther King. I had a dream, but I mean one night I was sleeping and I had a dream where I was standing in front of a bunch of appellate lawyers giving a talk about the existential crisis of appellate lawyers. And it was pretty fully developed. And I woke up and I actually remembered it, which I don't always remember my dreams. And sometime later that day, I wrote down most of what I could remember of it. It was about a page and a half, single space. And that was the origin of the paper. I've expanded it. I've thought it through more carefully and that sort of thing. But the basic concept came to me in a dream. And I don't say that to give it additional significance. I'm not pretending that it was the voice of God speaking through me or anything. And it's not something I'd ever thought about before. In the dreams, a lot of times things in your subconscious come bubbling to the surface.
Mm-hmm.
I was certainly not aware that I'd ever thought about this topic. But once it popped up in my dream, I started thinking about it more in depth and came up with, I actually sat on it for a couple of years and I shared it with a couple of friends and colleagues. And a couple of them said, that's interesting. You ought to share that with the world. And I had at least one that said, no, this is too honest, too real. You don't want to be talking in public. And there are some comments I'm going to make that could be misinterpreted about judges. So there was people that were uncomfortable about that. But I finally, Kirsten Castaneda called me last spring and said, I'm going to planning committee meeting for the UT Advanced Appellate course. And I just turned 70 last fall. And I thought, well, if not now, when? Might as well go ahead and put it out there. So I did. And my concept that there is can be an existential crisis in appellate law is based on 6 concepts and call them building blocks. So I'm going to go through those building blocks. I don't want this to be a lecture, and you guys feel free to jump in and ask me questions or add your 2 cents about any one of them, because I think each one of the building blocks kind of says something interesting about the practice of appellate law. So
Okay.
Unless you have any more preliminary stuff, I'll jump in with the first building block.
We are glad to study at the feet of the master, but we will ask intelligent questions if we can.
As best we can.
All right. So the first proposition is that practice of appellate law is a binary proposition. In every case, somebody wins and somebody loses. That's not to say there are different degrees of winning and different degrees of losing. In their cases that split the baby, certainly. But in every case, somebody's asking to somehow change the lower court's opinion and somebody else is resisting that. And the appellate court either does or doesn't. Like I say, there can be mixtures of that, but to some extent, every case you either win or lose. The other part of that is that law, especially litigation and appellate law, is the only profession I'm aware of where two professionals are pitted against each other, where they both apply their skills and someone declares a winner. You don't have that for doctors or accountants or any other profession I can think of. I mean, the closest parallel I can think of is doctors. Somebody might go to another doctor and get a second opinion, and then they choose one of those opinions, and they either get better or they get worse. But that's sort of an incidental ramification of that scenario. Whereas in the law, it's part of our system. Every case is that way. And I told somebody this, and they said, "Well, what about athletes?" Well, athletes are playing a game. Yeah, there's money involved, but it's a game. And here, there's a lot more at stake, and it's just kind of a bizarre system that we come to justice by having two professionals applying their skills, and one of them is declared the winner, and one's declared the loser.
And, in particular with appellate law, there are fewer opportunities for the sort of compromise that you can come up with in the trial court, because by the time you get to an appeal, the judgment is what it is. The issues are baked in. The facts are the facts. And it is a little bit more black and white in terms of, what the possible outcomes are. Whereas when you start a petition in a trial court lawsuit, it could go so many different directions, many of which you may not be able to predict.
Yeah. And, a lot of the cases I have are against people that are good friends. And we go into court and they do the best they can. And I do the best they can. It's like a really good sporting event where you say, I hate to see either team lose, except like I say, it's not a game. This is real stuff. And every time we're either publicly rewarded or publicly humiliated by the courts. It's part of our system, and it's unlike any other profession. So that's sort of the basic groundwork from which the rest of this jumps off from. So then the next building block is that winning is important. Like I said, it's not a game like sports. Our clients entrust us with their fortunes, their future, their freedom, their fundamental rights, especially somebody who's made the commitment to go forward with an appeal with the additional cost and time. They're really serious about protecting one of those four things. And so it's certainly important to the clients. And because it's important to the clients, it's important to us. That's especially true in cases where we develop a relationship with a client. And that doesn't happen in every case. I've had cases where, I barely meet the clients, or my relationship is with the trial lawyer. Some of those I exchange some emails with and they pay my bills. And others I spend a lot of time with and become good friends, friendships that extend beyond the life of the case. And especially in those cases, when you become friends with a client who has a great deal at stake, then winning for them becomes extremely important. But in addition to that, it's important to us because appellate lawyers, maybe more so than other types of lawyers, take a great deal of pride in their work and their craft. And the sort of public celebration of the quality of their work is winning or losing. Whether that's fair or not, we do take a lot of pride in our work, and we like to win a big case, and we hate to lose a big case. As I say, we don't have the luxury, because we're working for clients, of taking the Ted Lasso approach. And Ted Lasso kind of famously said, well, I don't really care that much about winning or losing. I just want to see these young men live their best life and do the best they can do. We can't say that as appellate lawyers. So for better or for worse, winning, every case someone wins or loses, and winning is extremely important for a variety of reasons.
I mean, even just the practice of writing a brief takes so much emotional and intellectual investment that is different than doing stuff in the trial court, which is not to say that there aren't, briefs and parts of trials that require a lot of emotional labor, but an appellate brief certainly does, because by the time you read the record, you do all the research, you put everything together, you check all the boxes, make sure all the rules are met. I mean, you've spent dozens, if not hundreds of hours putting that project together.
And as a result of that, Jody, I think you become deeply invested, not only invested in
Absolutely.
terms of time and money, but you get intellectually and emotionally invested in your arguments, and you want to be
Mhm.
vindicated and told that your argument was right.
Yeah, and you wanna be seen, as a problem solver,
Yeah,
because a lot of times, especially if you weren't involved in the case as it's brought to you, with, say, a judgment and the record already signed, sealed, and delivered, but you wanna be able there's a certain amount of pressure there to deliver value for what it is you're being hired to do and paid a lot of money to do.
right.
So yeah, this whole section just totally resonates with me because I always laugh though, and we may touch on this later, but when you get those, I don't want to say unsophisticated, but people who haven't been exposed to what appeals are very much, and they want to know what your win-loss record is.
Mhm.
That's a toughie because, as I'm sure we'll discuss, if you even approach the same batting average representing appellants as a regular MLB average batting average, you'd be a hugely successful appellate lawyer.
And that's interesting. I have heard that from clients before, clients that are trying to decide whether to hire me or my firm. But what's your winning
Mhm,
percentage? And I tell them quite honestly, I have no idea. I've never calculated. And a lot of them think I'm being coy and say, "Oh, surely you do.
mhm,
You're just trying to hide. You must have a low average." I said, "No, my firm doesn't get hired in easy cases. Every case
yeah,
we have could easily go either way,
Yep.
and and sometimes we win, sometimes we lose, but
Mhm.
that does get into something I'm going to talk about in just a few minutes.
yeah,
But you're right. That's a question I often get, and it's real appellate lawyers understand that's a silly question. Well, that does lead
yes,
nicely into my next building block, which is that uh, 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 every case one wins or loses. I mean, it's important, and there's this illusion that if you just work harder and do a better job and work harder and work smarter, then you'll win. You'll be rewarded for those things. That's kind of, to me, is sort of a naive version of the American work ethic that everything you can always prevail if you just work hard
Mhm.
enough. I hate seeing Olympic athletes from the podium say, well, if you just hang in there and work really hard, you can achieve your dreams. Well, yeah, there's a whole lot of people behind the scene that didn't make the podium or didn't
Mhm.
make the team who worked just as hard and didn't have the natural skill or body type
Mhm.
and didn't get there. It's
right,
not that simple that you can just work harder and expect to always win. I've had plenty of appeals where I know I outworked the other side and lost, and other cases where they may have done more work and won. And lost, but that's just not part of the equation. And yet we have this naive sense that, I mean, that doesn't mean you don't have to work hard at all. Usually both
Mhm.
sides work hard, but hard work alone is not going to get you there. And that leads directly to my fourth building block, which is really just a reiteration of the same point, which is that winning appeals is rarely based on working harder or doing a better
Mhm.
job of advocacy. And that really is as it should be. Appeals are supposed to be decided based on the law as applied to the facts. And in most cases, unless we get involved really early on, by the time the appellate lawyer gets on the scene, facts are already established. The law is
Mhm.
already established, and the court really should look at the facts and the law and decide who wins. It's not a referendum on the talents of the appellate lawyer. And like I say, it shouldn't be. And so this illusion that if I just work hard enough, I'll win. Sometimes you shouldn't win. But in
Mhm.
it, whether you work hard or not, the law is supposed to be based on. I mean, the decision is supposed to be based on other factors other than how hard the advocate worked. Now, I understand that there are cases where the quality of the advocacy can make a difference. The way that we present the facts and present the law can impact how the judges perceive it. And sometimes, if there's a dramatic difference in quality of advocacy, that may influence the court. If both lawyers are competent, effective advocates, that loses its effect. So you have to treat everyone as if it's one of those cases where you are making a difference. But like I say, cases are supposed to be decided based on the facts and the law. Your family of origin, or where you grew up, or where you went to school, or what classes you took, what professors you heard, what who you hang out with, who your friends are. And I'm not saying that any of that is improper at all. It is part of being human. And there's been a lot written, and I've read a fair amount on decision-making processes. There's just a whole
Mhm.
lot of, we hate to use words like bias and prejudice, but bias and prejudice isn't, they are scientific facts that have been proven over and over again by psychologists, and it's just something that we have to be aware of. Another part of the decision-making processes is that most of us tend to make snap judgments based on our first impression. And numerous experiments have revealed that after you make that first impression, it takes a whole lot to lodge you off of that, because our brains tend to accept information that is consistent with our first impression and screen out information that is inconsistent with it.
For those who are listening closely, I know you're not saying that skill doesn't matter, because the first thing I was thinking of there was, well, think about skills like being able to find that white horse case, or in terms of research skill or writing skill, or maybe just as importantly, issue selection skill. I think we all agree that those are things that make for a good appellate lawyer. But I think your overall point is that, you can be the most skilled person in all those areas, and sometimes you're just going to lose a case, and maybe even one that you think in your mind that you shouldn't lose.
There's no question that there are places where skill makes a difference. One of the ones you mentioned is issue selection. Another one is issue framing, the way that you word an issue, the way that you word an argument. There are a lot of places where mastering the craft of appellate advocacy can make a difference. It may be that the facts and the law are such that it doesn't make much difference, but there are certainly cases where at the margins it makes a difference, and you never know which case is going to be one of those cases. So you
Yeah.
have to treat every case as if your appellate advocacy skills are making a difference. And yet, in the long run, I'd say that probably the majority of cases turn out the way they're going to turn out, regardless of the skill of the advocates, unless you
Yeah.
have a dramatic disparity in skill. If one side is really good, the other side is not, that tips the scale. But when you've got two good advocates, the judges are going to decide the case based on the facts and the law, and the appellate advocates can help them with that, but they can't, by the sheer force of advocacy, turn the ship when it's headed towards the iceberg.
Yeah.
Right.
And, I think the flip side of that is true, that sometimes lawyers who don't do a lot of appeals get the wrong message from a win, that, well, that means that I did the best job and my argument was great and everything I did was wonderful. And not necessarily, and those are
Yeah.
sometimes hard cases to lose, where you read those briefs and you just think, my gosh, and then you lose anyway.
Yeah.
Yeah. I have a friend named Brian Weiss. He's one of the premier criminal appellate advocates in the state. And we talk a lot. And every time he has an argument, he comes back and I say, "How'd it go?" And he says, "Well, I won the moot court." And yet, um, for a criminal defense appellate advocate, he doesn't have a very good winning percentage. And he knows
Yeah.
that. But he likes to feel like he at least came away as the person who did the better job of advocacy. And you always have to strive for that. I'm
Hmm.
just saying that alone can't always turn a loss into a win.
I suppose it's a corollary to this overall point. I don't want to hijack it, and because I want to keep us on track too. But another, I guess you'd call it a skill among appellate lawyers is, uh, setting client expectations. And you can be like Brian and go in and win the moot court, and the client may get this idea that, well, hey, we clearly have the better argument, we should win. I know we're going to talk toward the end about some of the other roles that lawyers play, and that's just something that maybe I would add to the skill list. And I think
Hmm.
maybe that's consistent with your overall
Yeah.
approach to how to overcome the existential crisis. So I'll put
Yeah.
a pin in this and we'll come back to it.
Okay. All right. So the next building block, every case one wins or loses, winning is important. There's an illusion that you can win by working harder, but winning appeals isn't always based on who works the hardest or does the better job. The fifth building block is that despite your best efforts, no matter how good you are, you will sometimes lose, sometimes unjustly, sometimes catastrophically. If I hear somebody say that they've never lost an appeal, I know that either they've only handled very few or else they're lying. And as you said
Hmm.
earlier, Todd, it's not about your winning percentage. Anybody who's handled very many cases has lost some tough ones. And the better you are, the harder cases you're going to get. because if
Yep.
it's an easy case, if it's a slam dunk, trial lawyer can handle it themselves or handle somebody who's inexperienced and inexpensive. But if the better you are, the more you're going to draw the really hard cases, and you're going to lose a lot of them. My sort of trifecta of shame came in the first decade of this century when I had three big products liability cases that went to the Texas Supreme Court. They were all cases. I was working with a firm out of South Texas. They were all cases, product liability death cases, where the plaintiffs won the jury verdict with over $10 million in damages. They were all cases where the Court of Appeals affirmed the judgment from the trial court. And in all three cases, the Texas Supreme Court not only reversed, but reversed and rendered a take nothing judgment. And yeah, they were all cases that I thought I should win. We often think we should win cases, but the first two were cases where they all depended on the experts. And two of those cases, we had an expert. This was a good trial firm, and they had good experts who were highly qualified, whose credentials were not challenged, who had a theory of what caused the injury that was backed up by evidence. And in both cases, the Texas Supreme Court looked at both experts' theories and said, no, we believe the defendant's expert more than we believe the plaintiff's expert. Which, the other lawyer could come in here and maybe tell you a different story, but that's my version of what happened.
Yeah,
The third case,
I
it was a
understand.
pharmaceutical case, and we relied on numerous studies, most of which were done by the defendant. And the defendant decided this drug was so dangerous, they took it off the market, even though it was the best selling drug of its type in history. They took it off the market. We used their studies, and the court said the studies were not reliable. And, could I say that it might have had something to do with my clients were all poor Hispanic families and the defendants were all large corporations? I don't think any of the justices on the court at that time made that kind of calculation. I just think that they had a mindset that the law, products liability law, should go a certain way. And I had very good lawyers on the other side, and they were tough cases. And I'm not saying it's outrageous to lose, but to lose all three of them back to back, I had all three on contingency fee, thousands and thousands of hours, and no compensation. That's the kind of thing I mean when I say sometimes you're going to lose. Sometimes you're going to lose catastrophically. Sometimes you're going to lose when you think it's unjust, and that's just hard to swallow.
It is.
And I don't
Absolutely.
mean to be whining 20 years later about a loss,
No. You're proving
but
up your chops in this area,
That's
Kevin.
right.
I mean, that's that's an incredible, and in a bad way, run to go on.
yeah,
But I think it just goes to show you, because we know you to be an excellent advocate. And, if Kevin Dubose can't hold on to those judgments, I'm not sure anybody could. It highlights for me too, something else that I'm not sure exactly where it fits into this equation, but one of the frustrating things in my practice, and I think for many other people is, you advise clients based on the law as it exists at the time the case is going to trial or going up on appeal. And when something gets to the Supreme Court of Texas, the law may change
In your case.
on a dime in your case, and it may undo everything that was done before. And I think those cases, I haven't read those opinions. I probably have, but not recently. That is one of the especially big risks in doing that kind of work, before a court that doesn't grant plaintiffs' judgments to affirm them usually. So I guess it does come with the territory, but, for appellate judges who are out there listening, I would encourage them to think about, the impact of their decisions on real people. And I'm like you, Kevin, they're not sitting around thinking, I'm going to go and hurt this one person or this one class of people. But I think one of the most challenging things about what we do for a living is the relative lack of predictability in an area where it's supposed to be really predictable.
Yeah.
And so I hope that fits in with your topic overall.
It absolutely does, Todd. And that's what was so hard about those cases is that my trial lawyers were really good trial lawyers who knew the law and knew what they had to do and found the expert and got them to say the right things and found evidence for them to rely upon. And in each case, I felt like the Supreme Court moved the bar in our case. And I'm sure they felt like that was where it should be. And I don't think they were picking on us, but it had the effect of leaving devastated families in their wake, and not to mention lawyers. So So that all leads to my sixth and final point, which is apparent responsibility for catastrophic losses with limited control over outcomes can result in an existential crisis.
No question.
Those three Supreme Court cases are a good example, but it doesn't take something like that. Any thoughtful appellate lawyer who cares about their clients, cares about the quality of their work, cares about an outcome, when you have a devastating loss and afterwards you read the opinion and you think, there is nothing I could have done to have achieved a different result. One case not long ago where we lost the case on appeal, and the lawyer that had hired me called me on a speakerphone with their firm, small firm, 5 or 6 lawyers, gathered around a conference table with me on a speakerphone to ask me what happened and to get me to explain our loss, and said, well, damn, Dubose, I could have gone out and hired $100 an hour lawyer off the street and they could have gotten the same result that you could. And I think he thought that I would be defensive and spar with him about that. And I said, yeah, you're absolutely right. And if that's what you want to do next time, I would completely understand that. And it was particularly ironic because the reason for the decision was improper jury argument by that lawyer in the trial court. And I did everything I could to try to save it and couldn't. And yet I got blamed for the loss of appeal. I can look back and laugh now, but it can be devastating to lose big cases that really mean a lot to you when you feel like you didn't have any control over the result. And there's a couple of different ways that existential crisis is used in our vernacular these days. One is when you're talking about a company or an organization that's on the brink of extinction, and the existential crisis is not knowing whether you will continue to exist. That's not this kind of existential crisis. There's another meaning of existential crisis, which is some kind of loss that can cause you to question your role in the cosmos, what you do for a living, whether it makes a difference. And that just nails this on the head. I have had times in my career when I thought, why am I doing this? I don't make any difference. It just sets me up for heartbreak, and my clients too. That practicing law is something I enjoy most of the time, but there are days like that when it is really hard to keep going. So that's the existential crisis. When I first presented this paper as something that might be considered for a seminar, somebody read it and said, well, that's awfully bleak. Don't you have any ideas how to overcome this? And so I came up with some, but that was not part of the original paper.
Wow. Okay.
Yeah. Yeah. That's the value of having somebody else look at your work.
Yeah.
Make suggestions. So I've got some suggestions for how to deal with the existential crisis, which I will
Well, now that
share.
I'm thoroughly depressed about what I do for a living, I'd love to. Okay, Kevin.
So the first thing is you need to redefine your concept of success. Success doesn't mean whether the Court of Appeals decides to rule in your favor or not, because you don't have a lot of control over that. It means, did you do the best job you could do as an appellate advocate? Did you review the record and come up with the evidence that's most helpful to your position? Did you select issues well? Did you frame those issues in a way that's most conducive to get the court to answer the questions the way you want? Did you construct a brief that's artfully constructed so that it presents summaries up front that the court can read rather than building until the conclusion at the end? And all the other things that we do as advocates. And did you argue in such a way that you were not combative and putting off your audience, but engaging in a discourse with them? All the things that you can do to persuade the court. If you do those things, then that's a success. That doesn't mean you don't try to win or care about winning. You have to, but it means that you have to sort of embrace the dualistic philosophy of people like Ram Dass and other spiritual teachers who preach total involvement and complete detachment simultaneously. So you can be totally involved in your work and try to do the best you can do and treat it like it matters and it's important, but at the same time, not be attached to a particular result. A lot easier said than done, but if you can embrace that kind of duality, that's the best way to cope with this. However, there's a huge caveat that works for appellate lawyers and for your own wellness and mental health. It does not work for your clients, because to them, winning or losing is everything. That's the really hard part about this existential crisis is you can't just say, well, it doesn't matter. It still matters a lot to the clients. And this is maybe their only appeal with you. They don't care about how good a lawyer you are. They just want to win. So to know that they're that attached and have to be, and you can't control it, is what creates the existential crisis. But to the extent that you can, you should try to define success in a different way for your own personal well-being. The second suggestion is that you lean into the other roles that a lawyer plays other than being a fierce advocate and a warrior on the battlefield. One of the things that we are also supposed to be is a counselor. And that means that, as Todd was saying earlier, you manage expectations.
Mhm.
You don't, well, first of all, at the beginning, you can counsel a client not to pursue an appeal. If you've done this for very long, even though
That's
it's
right.
unpredictable, you can at least tell that there are some cases that are not worth pursuing and others that definitely are. And if you can,
Mhm.
some of my best work I've done as a counselor is advising people not to pursue an appeal, even though they're willing to
Yep.
pay me to do it. And it might be to my advantage to go ahead and take it up there and take one on the chin and make a lot of money. That's not what drives me. I'd rather tell the client to save themselves time and money and heartbreak. It can also be, don't argue that point, even though that's the one you're most emotionally connected to. That doesn't have a very good chance of prevailing, and it may turn the judges off by us even raising it. So you can advise not to take an appeal. You can advise not to argue certain points or the way in which you argue certain points. But the other thing is, once you decide to go full bore, you have to make them aware what the statistics are, that most
Mhm.
appellants don't win, that it's an uphill battle, all of those things. You should never get a result and communicate to your client and have them be shocked. They should always
Right.
know that the worst case scenario is a possibility, and that can at least soften the blow a little bit for them, even though they are attached to the outcome.
Yeah. I find sometimes you have that conversation up front about this is a tough one. The odds of success aren't good. And then of course you go through the process of briefing and arguing and you're on board and you're buying it all. And then when you lose, you have to remember and go back to your notes and say, oh yeah, that's right. This is why I remember this being a long shot. It's hard to eat your own crow.
I've had to do that, Kevin,
Yeah.
a couple of times, at least this year, counsel clients that, look, I just don't think that your money is well spent pursuing an appeal here. I think you will be better off
Yeah.
not letting this occupy your brain for the next couple of years and cut your losses and move on.
Yeah.
And you're right. I mean, I think that's one thing that the clients don't always understand. They're like, well, wait a minute. I've hired you and you're telling me you don't want to do the work. And I'm like, well, it's not quite that simple. I've got an ethical obligation to tell you. And that's something I tell every client when they first come in the door. It's like, look, if I don't think you've got an appeal that's worth pursuing, I will be the first one to tell you. And you can feel free to move on and find somebody else to handle it for you. But this is
Yeah.
part of my job, is to tell you,
Yeah.
give you an honest assessment of what I think about your case and the prospects for success. But even if I do think it's worth pursuing, here are the, all the other things that you've already mentioned, the statistics. One of my favorite things to say lately is, well, that the appellate courts as an institution are made up of human beings, and human beings make imperfect decisions. And if you get, until we get the robot judges, and who knows if they'll even make perfect decisions, but this is the system we have. And as long as we have it, we really cannot predict with any certainty. Nobody's going to go to Las Vegas on the odds that we could give you.
Mm-hmm.
And it's a tough conversation sometimes, but you've taken the words right out of my mouth as far as being a counselor. I think that's a role that us appellate lawyers especially need to keep close, because it's one I think that doesn't get enough attention and isn't utilized properly enough.
One of the really interesting places where those words of caution and counsel come into play. So I've been involved in some situations over the years where a client was interviewing several lawyers or law firms, what we called a beauty contest. And we went in and talked to them and said, this is going to be tough, and here's the things against us, and, we'll do the best we can, but we can't guarantee anything. And they'll call us a couple of days later and say, well, we hired this other firm because they told us that we were right, and they were on board and enthusiastic, and said, we're going to go up to the appellate court and we're going to kick their ass. It's like, okay, that's their problem, not my problem. And I didn't have any regret about not getting those cases, because I knew that they were going to have some hard conversations down the road. And I'd rather not have a client that is looking for that for blind
Yep.
optimism that we're going to win just because we're right. So yeah, you have to be strong in your convictions. So another thing that you can do to assuage this is for the occasions when it does make a difference, you can improve your craft all the time. I've been doing this a long time. I think I'm a lot better than I was when I started, and I'm still learning every day. And as we've talked about, there are cases where the quality of advocacy can make a difference. I have to treat every case like it's one of those. And so I continue to go to seminars and watch podcasts and try to pick up things from other lawyers and try to improve in little small ways that can sometimes make a big difference. So even though I don't think it always makes a difference, I can't turn a blind eye to that. And I have to always try to be improving my craft so that when it might make a difference, I can take advantage of that.
One of the things you mentioned was, knowing your audience. And I think that that's a lot of a place where we add value as appellate lawyers is an appellate court, and each particular appellate court is its own unique audience. And so understanding the nuances of that and the types of issues and arguments that they care about and are watching for and that can impact them really does make a difference. Because if you frame it in a way that's going to, especially with the Texas Supreme Court, if you frame it in a way that's going to resonate with them, that's going to take your case out of the 5 to 10% pile and put it up into the 25 to 30 to 50% pile, which still isn't great odds, but it's a whole lot better when you're talking about discretionary review.
Yeah. And, in the Supreme Court, you always know who your audience is. And unfortunately, it's 9 people that may have some significant differences between them. But in the courts of appeals, when you're writing your brief, if it's a court with multiple justices, when you're writing your brief, you don't know which 3 judges are going to be on your panel. Mm-hmm. Or in the Fifth Circuit, you don't know which 3 judges you're going to have. So It's hard to do that when you're writing the brief. It's a different game after, if you get oral argument and you get your panel, then you can do things like study previous opinions by the judges on your panel. You can talk to people that clerk for that judge or people that used to practice law with them that know them well. And then you can get much, much better about tailoring your arguments to your audience once you know who your audience is. Mm-hmm. And with 3 judges on a panel, that's a small enough group that you can sort of manage that a little bit better than when you've got 9 justices. It's a little more challenging.
Definitely.
Yeah, for sure.
And then the fourth suggestion I have for dealing with the existential crisis is go ahead and confront your loss, own it, read the opinion. I have a tendency not to read opinions when I lose, but read it and see if there's anything you could have done differently. See if there's anything you can learn from the opinion and fully own it and grasp it, and then put it behind you and go on to the next case and start working on that as hard as you can. That's really the only way to get over it, is to find something else to work on. And again, I wouldn't do that too quickly. You need to confront it. But after you've done that for a brief period, then you go on to the next case and immerse yourself in something else. And fortunately, there's a lot of cases out there. You may have a better chance the next time around. And gradually that existential crisis starts to fade. And the final tip is, if it doesn't, seek help if you need it. There are a lot of resources. I often tout the Texas Lawyers Assistance Program. It's anonymous. They love to help people. They do it all the time. And they are really kind of associated with abuse, drug and alcohol abuse, but they deal with mental problems too. And I know a whole lot of people who have sought help and got counseling, and it really made a big difference in their lives for any one of a number of reasons. If your existential crisis doesn't go away and you need to talk to somebody, or talk to a friend, talk to a partner, talk to somebody, don't just bury it and act like you're the only person in the world that's ever had this and you're weak. It's not a weakness. If anything, it's a sign of caring too much. But if you need help, go get it, take advantage of it, and that should help.
That's a great point. And I guess this also comes back to the point you were making about getting that phone call and being on speakerphone with the entire law firm asking you, well, what happened? What went wrong?
Right.
But that's a tough call to have in any circumstance when you're having to break bad news to the client. But when you got the client kind of sliding in their view that it was somehow your fault.
Yeah.
That they lost, especially under the circumstances you mentioned, Kevin, when you were trying to pull them out of the fire on a bad jury argument. This may be another area where having a good mentor who does what we do and can help you kind of shake it off who's dealt with this kind of thing before. I'm thinking really about the young appellate lawyers who haven't developed maybe the skin as thick as what we've all been able to develop after doing this for at least a couple of decades. That's something that's probably worth mentioning is you really talk to a friend, talk to a partner, but don't just internalize it and think that it's all your fault, because for all the reasons that we've talked about, and Kevin, I really, really like this outline, and I'm so impressed that you conceived of this in a dream and remembered so much of it, because I think these are important things to remember. But, I think the takeaway there at the end really is, look, it is important to kind of pick up and move on to the next, learn what you can, but don't internalize it to the point that you think you're a bad appellate lawyer because you lost a case. If you do that too much in the beginning, you won't last in this area. You have to be able to, as I say, shake off the dust and move on to the next.
Well, your point about the client saying what happened reminded me of a story that's one of my favorite appellate stories, and I never thought of it in connection with this presentation, but it kind of fits. John Roberts, before he went on the Supreme Court, was an excellent Supreme Court advocate. I think he argued 45 cases in the Supreme Court. And I start to say had a good winning record. Some people actually do keep those, but he argued a case in the Supreme Court and called the client and told them that we lost. And they said, well, what was the vote? And he said, well, it was 9-0. And they said, 9-0? Why was that? And he said, well, because there were only 9 justices.
Kevin, we really appreciate this. This has been an interesting kind of thought-provoking topic, and one that makes perfect sense, but I hadn't really ever put in these terms. This is great. So we really appreciate you joining us.
Happy to be here. I always enjoy talking to you guys.
And we will see y'all next time.